The Honorable Eric J. Eisnagel, Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge Eric Eisnagel. I'm joined on the panel today by Judge Makar on my right, Judge Saud on my left. And we have one case on the calendar this morning, and that is 24-1567 Lewis versus Norfolk. Right. Each side has 20 minutes for their argument. We can save whatever time you'd like for rebuttal for the appellant. If you'd let me know beforehand, I'll attempt to help you keep track of that. Ultimately, it's your responsibility, and you can use your rebuttal time whenever you'd like, and before or in rebuttal. So with that, please silence any electronic devices you have. And oh, did you switch? Okay, very good. No, it doesn't matter. It doesn't matter at all. Usually appellant sits over here, but it doesn't matter, so that's fine. So, counsel for appellant, if you're ready, you may proceed.
May it please the court. I'm Jonathan Sternberg, and I represent the appellant Priscilla Lewis, who's the widow of the decedent Clarence Lewis. And, Your Honor, I'd like, if possible, to reserve 5 minutes for rebuttal. As Your Honors know, Mrs. Lewis appeals from a summary judgment in favor of the Norfolk Southern Railroad on her wrongful death negligence claim for damages under the FELA. The trial court excluded her liability expert, Dr. Paul Rosenfeld, holding that Dr. Rosenfeld's testimony that Mr. Lewis was substantially exposed to carcinogenic toxins, diesel exhaust, and benzene during his railroad work at levels that the railroad knew or should have known risked cancer, and that the railroad breached its duty to Mr. Lewis under the FELA in failing to mitigate this, was inadmissible under the Daubert standard. And because Mrs. Lewis then had no liability expert, who her medical causation expert could base his exposure and other reliance on, the court granted the railroad summary judgment. Your Honors, excluding Dr. Rosenfeld and granting the railroad summary judgment was error. This court should reverse the trial court's judgment and remand this case for trial. The trial court fundamentally misapplied the liberal admissions standards for expert testimony in Florida statutes.
Counsel, given that the expert here, Rosenfeld, right?
Yes.
Was a liability expert.
Correct.
Can you walk me through why is there so much discussion about his opinion that his methodology being applied to CLL versus lung cancer? Given that he's a liability expert, how relevant is that argument?
Sure. I'm glad Your Honor asked that. So a couple of responses to that. So to start with, we attacked three conclusions that the trial court made in excluding Dr. Rosenfeld. And the first, I think, confused what he was testifying about in the first place. The trial court says on page 2 of its opinion that he had opined that the exposures were, quote, the cause of Mr. Lewis developing the form of cancer he did, CLL. Dr. Rosenfeld never testified that at all. That was, in fact, he expressly said he's not qualified to do that. He's not a medical doctor. He's a PhD in industrial hygiene and things like that. He was only testifying what he concluded the exposures were. That is, that there was a substantial exposure to these toxins, that risks cancer, and that violated the standard of care that the FELA sets for railroads to their employees.
And if that was his role, why would it matter whether it was connected to CLL or some other type of cancer?
That's exactly where I was going, Your Honor. It doesn't. That's the second main problem with this. So you're right. The trial court said that his methodology wasn't validated for assessing risks associated with CLL, chronic lymphocytic leukemia.
It sounds like a causation issue.
Exactly.
Did the causation expert rely upon Dr. Rosenfeld's data and findings and opinion?
So the causation expert, Dr. Levin, whose report is also in the record, relied on these exposures, and then he was the one who translated that into this goes to CLL just as well as any other kind of cancer. What Dr. Rosenfeld was assessing was a cancer risk generally. While it's true, he said, this goes to lymphocytic cancers like CLL, it was really a general cancer risk. I'll note that in his, and I think we show this best in our motion to reconsider, which is pages 779 to 81, at least on those pages of the record, that his exact methodology had been used to weigh other cancers besides lung cancer. But I agree, Your Honor. I think that's an important distinction, and I don't think the railroad really has an answer to that. CLL doesn't matter for the purposes of the liability expert. The FILA creates a duty, a non-delegable duty, for railroads to give their employees a safe workplace. What Dr. Rosenfeld found, and not just from, as I know this is going to be an issue too, not just from this translation he did of elemental carbon into the diesel particulate matter and finding what scientifically these exposures likely were, but really just from the testimony of Mrs. Lewis and Mr. Lewis's coworkers, as well as railroad industry data and internal data from Norfolk Southern, showing that there was this substantial exposure. They did nothing to mitigate it. He went through the history of knowledge about these things.
Would the testimony of the lay witnesses been enough for Dr. Levin? Is Dr. Levin's your other expert, correct, the causation expert?
So, yes.
Would that have been sufficient by itself for Dr. Levin to render a causation opinion?
So I think first you would have to have a liability expert like Dr. Rosenfeld translate that equals a substantial exposure, which is what he did. And I think that the trial court, so Dr. Rosenfeld had two...
Would Dr. Rosenfeld have to, would all the calculations that Dr. Rosenfeld did, were those necessary, or what I'm asking is, was the lay, it sounds like in your brief, it sounds like you take the position almost that the lay testimony was sufficient by itself, that Dr. Rosenfeld didn't need anything else in order to provide the exposure opinion.
And you are correct, Your Honor. So there are two parts to our brief. The first is, even without this exposure data, without his translation, his use of the IRIS system and all of that, even without that, the lay testimony and, of course, the internal data. It's not just the testimony alone. You have to show that there was a failure to mitigate. But the lay testimony alone is enough. And it's not just us who are saying that. We cite cases on pages 44 to 43 and 51 of our initial brief. The ones on 44 to 43 are FILA cases from throughout the country, especially the Payne case from the Tennessee Supreme Court, which is really on all fours with this. There wasn't some kind of translation into elemental carbon and all of that. There was simply a liability expert relying on testimony of coworkers, and I think the decedent's wife there as well, about what these exposures were and the internal railroad data. And one thing the Tennessee Supreme Court pointed out was to hold otherwise, to say that this wouldn't be enough, would essentially reward railroads for not having measured this data when they could have, and then saying, well, now because we don't have a time machine, because we can't go back in time and see exactly what these exposures were, that lay testimony isn't enough. But I think the cases on page 51, especially the Northrop Grumman case from the 3rd District in 2017, that was an asbestos case. There was no finding of exactly what the exposures were, but and I believe the plaintiff there was still alive, and he testified what his job was and how he worked around asbestos, et cetera. And the liability expert, I think was both a liability and causation expert there, were able to say, as a result, these were substantial exposures to asbestos. We know that asbestos causes mesothelioma, et cetera, et cetera. There's also the Hawthorne case from the 1st District in 2018 and the Booker case from the 1st District in 2015. Those were during that period where the legislature had made Daubert before the Supreme Court declared it unconstitutional. But those are Daubert cases, despite the years that they're from.
Counsel, you earlier said that the standards are a liberal one under Daubert, right? And
They are.
I always thought it was a little bit different. I always thought it was a heightened standard, meaning that the trial judges now are gatekeepers. They're supposed to apply rigorous analysis to make sure that junk science doesn't come in. So when you're saying it's a liberal standard, I see you cited a federal appendix case. It's not a federal 4th or whatever, 11th Circuit, kind of an unpublished case for this liberal standard. Is that truly the standard around the the nation and in Florida?
So, yes, it is, Your Honor. And I believe in the federal appendix case, they were citing a different 11th Circuit case holding that it's a liberal standard. But yes, the point to Daubert was that it liberalized what had previously existed under Frye. And that there are cases from throughout the country that say that. I agree the trial court's a gatekeeper, but there are standards that the trial court must apply. And what we explain in our brief is the three main conclusions that the trial court made here themselves were legally error. So the other side harps in their brief on the fact that this is a discretionary decision, that the court employs an abuse of discretion analysis in analyzing a Daubert exclusion. The problem, though, is if a trial court misapplies the law in exercising its discretion, that itself is an abuse of discretion. That's the Pantoja case from the Florida Supreme Court that we cite, and a couple of other cases from this court, too. And that's reviewed de novo. So the point here is that in determining that Dr. Rosenfeld's conclusions were inadmissible under Daubert, the trial court fundamentally misapplied Daubert in three different ways. To reach three different conclusions. One being that he was opining on causation when he certainly wasn't, and that's just from the record you can see that that's not true. But more importantly, Daubert is about it's about reliable methodologies, not the application of those methodologies. And here the real problem is the trial court.
Daubert not about both? It's about reliable methodologies, but they have to be reliably applied to the facts and data in the particular case.
That's true, Your Honor. But what I mean by this is a challenge to the reliability of a methodology itself is within the gatekeeping role of Daubert.
Sure.
A challenge to the application of that methodology, however, goes to the weight of testimony, not its admissibility. If they have a different expert who says that my expert misread studies, right, that they disagree with his statements about what are in studies, if they disagree about the way he performed the calculation about translating elemental carbon into diesel particulate matter, those go to the weight of his testimony and not its admissibility. What the question is here is what are his methodologies? And he had two. One was, as we've discussed already a little bit, that he relied on lay testimony, which is certainly a methodology, that he reviewed studies, that he relied on his personal experience to come to his conclusions. Those are reliable methodologies.
What about his calculations, though? Right, that's part of the methodology, isn't it?
That's a second methodology. So he used two.
Let's talk about that one.
Excuse me, Your Honor?
Let's talk about that one, the calculations.
Yes.
DC to DMP. Let's talk about that.
Sure, I'm happy to. So there, the trial court, its conclusions were that it wasn't peer-reviewed, that it wasn't validated for assessing risks with CLL as opposed to other forms of cancer.
Has Dr. Rosenfeld published this the way he calculated it? Did he publish it?
Actually, he had. That's exactly right, Your Honor. It's on page 56 of our brief. We have the citation and a link, I believe, to the study where Your Honors can look at it for
When was
yourself.
it published? Roughly.
You caught me.
No, don't worry about it. So regardless, I can refresh on that. But regardless, it has the ability to be peer-reviewed. It's published.
Absolutely, Your
This
Honor.
exact way he calculated it.
That's exactly right, yes.
Had that been peer-reviewed or published prior to Dr. Rosenfeld doing so?
So what he testified about that is that each level of this calculation was based on well-established existing data. He started with an EPA guidelines equation quantifying the chronic daily intake for exposed workers that were similar to Mr. Lewis. It's direct from the EPA. Then he calculated a range of worker inhalation cancer risk values by taking those levels and multiplying them by the EPA's recommended diesel exhaust inhalation risk. And to do that, he did use peer-reviewed data, and this is Record on Appeal pages 54 to 56, that's in his opinion, or in his report, where he goes through the studies that say this is the proper way to do that. This then results in a table and a graph of the worker inhalation risk of the diesel exhaust at varying levels and varying exposure.
Go back to the
conditions.
exposure, though.
Yes.
You're past the exposure now. You're talking about the risk for cancer, right? So go back to the calculation of the exposure.
Sure.
How often has that been done? the way he calculated it.
He testified it had been done before, you're saying the initial estimate for how much elemental carbon
The
someone in this
exposure,
position.
right.
Yeah, so that's on pages 50 to 51 of his opinion, and it's an EPA guidelines equation. How often that had been done or not, I don't know, but the question of acceptability, which is what Daubert is concerned with, is could a scientist reasonably, based on something existing, apply this? And he certainly could.
Isn't one of the points of Daubert that we no longer exclude expert testimony just because it's not widely accepted within the scientific community?
That's exactly right. That's the main difference.
Under the old standard, even if it was correct, or even if it looked correct, like it might be correct, until it was widely accepted, we excluded it, correct?
That's exactly
Isn't
right.
one of the points of Daubert that is no longer the case?
I agree with you.
Okay.
I agree entirely, Your Honor. The conclusion that he drew from all of this was based on, after doing this translation, that at 39 years in the railroad, in the particular job that Mr. Lewis held, that he had a substantially increased risk of developing cancer generally. And then
Did the EPA calculate exposure? Did the EPA calculate exposure the same way that Dr. Rosenfeld did?
my understanding from the record is yes.
Okay.
Again, pages 50 to 51, he cites the EPA guidelines and the studies for that.
So did EPA convert it from elemental carbon to diesel particulate?
No, he was using other peer-reviewed literature for how that is done. It's the IRIS system, the individual risk. It's not just the EPA, it's a system that's used by the military, the CDC, and the EPA, the Integrated Risk Information System. And what he did is called a demonstrative health risk assessment. And that's on the record. I see that I am just into my rebuttal time. If Your Honors have no further questions, I'll see you on rebuttal. Thank you.
Thank you, counsel. And counsel for the appellee, whenever you are ready, you may proceed.
May it please the court, my name is Ira Potizer. I'm from Pittsburgh, Pennsylvania, and I represent the appellee Norfolk Southern Railway Company. This is my first time appearing in front of any Florida court, so I'm very grateful for the opportunity today. I think Mr. Sternberg's outlined what the issue is here pretty well, but there are a couple of things I want to kind of clean up. Number one is this whole question of what is the proper standard of review. And as we've pointed out, well, in this case, there's basically two. For the summary judgment, it's de novo. But for the reviewing Judge Feltel's decision to exclude Dr. Rosenfeld, it is abuse of discretion. The other side argues, they argued this on reconsideration before Judge Feltel, is saying, well, this is really not a question of abuse of discretion. It's really a de novo inquiry because you misapplied the law. I guess in a narrow sense, any time you might reverse on a question of an expert where the law is established here, 90.702, you could maybe try to categorize it as a mistake of law that's subject to de novo review. I think that kind of takes things way, way, way too far. Number one, Judge Feltel cited to and applied 90.702/Dalbert. I don't think there's any question. Now, they might disagree with some of his conclusions concerning the reliability of the methodology that Dr. Rosenfeld applied, but that does not get us into the realm of de novo review. It keeps us, if he misapplied something, if that's the argument, it's still a question that's subject to abuse of discretion, which I don't have to tell all of you is a very deferential standard. Basically, you have to say that no reasonable judge would have ruled the same way that Judge Feltel did in this case on this record.
Is there any body of railroad diesel exhaust liability cases out there?
I'm sorry, Your Honor.
Is there any body of railroad diesel exhaust liability cases out there? What I'm getting at is, how is it typically proven?
This has come up in other cases. I mean, I argued one in Pennsylvania not long ago. So this does come up. But each case obviously has to be judged on its own merits. And there are several things that the judge found in this case that I think are fairly unassailable. Number one, and even as Judge Sood, you've pointed out, under Daubert, general acceptance is not the talisman. That was the standard under Frye. But you still have to prove, even if you have a theory that is not generally accepted. And I think Dr. Rosenfeld pretty much acknowledged that this is kind of new ground that he's undertaken here and coming up with this, with the gold standard for calculating diesel particulate DPM is to measure elemental carbon and compare it to guidelines. He converted it, he did it kind of the opposite, and then he applied the EPA Superfund standards to it.
First, welcome to Florida.
Thank you.
Has Dr. Rosenfeld's methodology of converting elemental carbon to diesel particulate matter, has that conversion calculation been peer-reviewed, studied, subjected to scrutiny prior to his employment of that methodology?
I don't believe it has been. That was the finding that Judge Feltel made, and he himself kind of acknowledged in his deposition that this is new ground. This is really different.
But it can be peer-reviewed, right? He published an article.
Well, as we point out, pages 26 to 28 of our brief, I guess he was attempting to prepare an article on this, and for whatever reason, now maybe things have changed in the interim, but at the time, this article had not been published. I don't think anyone's ever evaluated whether this is an acceptable, reliable method of determining diesel and benzene in the atmosphere that could injure a worker. So I don't think I would say that he's kind of alone out there. Now, as Judge Sood, as you pointed out correctly, that doesn't necessarily, under Daubert, that doesn't necessarily make it inadmissible. But when you look at the totality of what was done here, when you look at the fact that there was no visiting of Norfolk Southern facilities, when all he relied on really was the testimony of lay witnesses. So,
How would visiting a facility now,
pardon me?
how would visiting a facility now be reliable at all?
Norfolk Southern does also have data. They take measurements regularly, and he didn't look at any of that. But in terms of determining whether
Data.
they've done anything to mitigate,
On diesel particulate?
pardon me?
What data? What data was available?
That I'm not sure about, Your Honor.
Well, then I'm not sure it's relevant.
Yeah. Well, at the same time, he did say he couldn't point to, and this is kind of skipping over to the argument that Norfolk didn't undertake any kind of effective mitigation. Without examining what they did or what their policies are in place, I don't see how you could possibly come to that conclusion in terms of use of respirators and things like that. One other point I think I need to address that hasn't been addressed yet in our discussion, and this comes up a lot. It concerns whether the FILA, this is the statute that's at issue here, creates a lesser standard for admissibility, because FILA, as they point out, is a remedial statute. It's not a strict liability statute. It has a slightly lower threshold of negligence than common law negligence. And the cases that we discuss at length in our brief, I think, thoroughly rebut that. That's number one, as a matter of law, the authorities that we cite don't support their.
But let's assume for a moment you're right about that. Why is the way that Rosenfeld did his calculation, did the conversion, why is that unreliable? I understand your position is, well, it hasn't really been done that way, and his article at the time of the trial judge's ruling, and I'll go back and check this to make sure, but your position is that it hadn't been published yet. But nevertheless, under Daubert, we still have to ask, why is it not reliable? The calculation, the conversion itself.
Well, number one, as Judge Felto pointed out, there's no consistent rates of conversion. There's no generally accepted conversion rate that can be applied to his calculations. And the last thing, and I know you focused on this during your discussion with Mr. Sternberg, is the question of lung cancer. Everything that has been done, every study has related to exposures as they relate to the development of lung cancer rather than the disease that he is suffering from.
Wouldn't that go to causation, not liability?
Actually, I would disagree with that, and here's why. Number one, in their reconsideration motion, they said his opinion on exposure is, quote, the fundamental prerequisite for plaintiff's medical expert, Dr. Levin, to establish causation. So the question here is that they've conceded that without establishing unsafe workplace, we don't get to medical causation.
Well, no, Levin, well, maybe I misread it. I thought, as I read it, Levin just needed the exposure opinion.
Right.
Right?
Right. But
So that's what I'm asking about. Why is that calculation, that the way that Dr. Rosenfeld did it, why is that not reliable? I understand that you're saying, hey, look, it hasn't been done a whole lot, right? Maybe not at all. But why is it not reliable?
it's for some of the reasons I exposed, like no consistent rate formula for conversion, and then plug it into the EPA standard, which deals with lung cancer,
Right.
rather than the
Superfund.
Superfund.
Right.
Yeah, and the other thing too is that I find interesting, and maybe this isn't a great legal point. One of the problems I think with the EPA Superfund, number one, they mention that there are railroad sites that are Superfund sites, but they don't say this one was.
Yeah.
And
let's
number
assume for a moment that the Superfund thing, that we view that more as causation. Just as, I'm not asking you to concede that, but just let's put that aside for a moment. If we're just talking about exposure, right? Why is the lack of a well-established rate of conversion? Is that how you said it? Why is that not just something that? Why is that not just for cross-examination?
Because the gold standard for doing this is, and which he concedes in his deposition, he said that the standard that is applied, that's usually applied, and I think Mr. Joyce during the argument at the summary judgment and motion said this too. He said the gold standard is you measure the elemental carbon and compare it to the exposure guidelines.
Right. But we don't need the gold standard. It's Daubert. We don't need the gold standard.
I'm sorry?
We don't need the gold standard under Daubert. We need reliability, right?
Right.
So,
But at the same time, he's using an untested version too. And the fact that you don't have consistent conversion rates, I think, renders this inherently unreliable.
okay.
And I think the other fact too, the other factor again is that I can see where there's maybe some confusion. I think they make the argument, it's something that you've touched on during Mr. Sternberg's presentation, that did Judge Feltel kind of go over into medical causation and make a medical causation judgment? Because, and I think that all stems from the lung cancer, and I would say no. He didn't make, I think Judge Feltel was very actually careful to say that his methodology goes to whether there was an unsafe workplace. And he didn't delve into whether this caused it, because that is Dr. Levin's realm. So I think when you look at his findings and you look at the evidence, you'll see that we're not in the realm of medical causation. There is no finding by the judge made there. We did challenge Dr. Levin. The oral argument on the motions also included the motion to exclude Dr. Levin, but there was no finding made on that. It dealt solely, and you have to have both. And one thing, when Mr. Sternberg and I were chatting before court convened today, and said this is a little bit unusual. A lot of times you'll see the judge go directly to the medical causation expert and grant a Daubert motion on that, and then grant summary judgment based on that. So in this respect, we have to go from A to B. We never got to B because he excluded Dr. Rosenfeld. So that makes, I think, procedurally this is a tad unusual, but nevertheless, under the abuse of discretion standard, which I think is very, I don't think there's really any serious dispute.
The abuse of discretion standard might be modified when we're dealing with evidentiary issues. This application might be a little bit different than in other contexts. Have any federal courts admitted the methodology used by Rosenfeld here?
I don't believe there have been any, Your Honor.
Okay.
If there are, I'm not aware of them.
Okay.
Counsel, I do hear you conceding this is an exposure case, meaning the plaintiff's expert was just trying to come up with a methodology to show what level of exposure the deceased had during his employment, correct?
Correct.
So as I'm conceptually thinking about it, how long did this individual work for Norfolk?
Many, many years, like 40 years.
Okay, a
yeah,
long
he was
time.
there. He was there a long time.
Okay, so he was perhaps in a lot of different job positions. So maybe the first 10 years he worked as a railroad yard maintenance guy. And then 10 years later he worked as a conductor. So he was in a number of different capacities, and those would have different types of exposure rates. It wasn't as if perhaps he was working in the train, the locomotive repair shop where maybe the benzene and diesel fuel fumes were high all the time. Was that type of analysis done here, or was it focused on his entire career or a segment of his career? Just kind of help me conceptualize what how the exposure rate was determined.
I think one of the problems, Judge McCarr, is that I don't think there was any kind of analysis done as to his specific workplace or any kind of readings there. And so that's where I'm troubled a little bit by the whole Superfund. I know I hate to always harp on it, but that's where I'm troubled by using this conversion method for Superfund sites, where this is not a Superfund site. And
why would that matter?
Pardon me?
Why would that matter?
When I think of Superfund, Your Honor, I think of things, and maybe I'm being way too simplistic here, I think of things like Love Canal and things like that. I mean, really, CERCLA, RCRA, things that the government comes in to clean it up and And Love Canal caused, all kinds of damage to
But
people.
why would the calculation work there and not in this case?
I don't even know if it necessarily would work there, but I just think
If this was a Superfund case, you might be in trouble, right?
possibly, if this was a Superfund site, maybe, perhaps. One of the things, too, that's interesting is that, and I think their argument is, and I could be completely misstating what Mr. Sternberg said, but he was saying that the type of cancer, for purposes of Dr. Rosenfeld rather than Dr. Levin, doesn't really matter. I think that's what he's saying. And one of the things I thought that was very telling when this came up during his deposition was, and I'm paraphrasing, when we asked him about this connection to CLL, he said, well, diesel is, I thought kind of cavalierly, diesel is bad for you, and basically anybody can get sick, and we don't recommend anybody, it's detrimental to your health. And my point is, how scientific is that? I mean, that's something that I
Hold
could
on. He
say
was
or you could say.
So maybe he was shooting from the hip on causation, but that's not what that's not what his opinion was for. He was a liability expert, right? He wasn't a causation expert.
Right, but I still think that what he has to say in order to satisfy the fit requirement has to at least be relevant to the type of cancer that they're alleging in this lawsuit.
Let me ask you this before your time's up. Why isn't the Gonzalez case, the district court out of Colorado, why isn't that looks, I mean, I'll go look at it again, but it looks pretty close. Rosenfeld, or at least someone named Rosenfeld was the expert in that case, and the federal district court concluded that, I lost the spot, but this concluded that whatever calculation you did there on elemental carbon was past the Daubert standard. Have you read Gonzalez?
I have not read Gonzalez
Versus
recently.
BNSF Railway Company.
Yeah. I'd have to go back and look at it again, Your Honor, in all candor. I don't know if the question of his methodology that he applied in this case came up, but I will have to look at it again.
Okay.
All right. Thank you, Your Honor.
counsel.
You look armed and ready,
I
but
am.
can I start with a question?
Please, Your Honor.
So as the proponent of Dr. Rosenfeld's testimony, is it the plaintiff's responsibility to present sufficient indicia of reliability? Or is it
Certainly.
presumed reliable?
Oh, nothing's ever presumed reliable.
Okay,
We
so
certainly
the
have to-
plaintiff has to present sufficient indicia of reliability.
I agree with that.
So what indicia exist as it pertains to Dr. Rosenfeld's conversion from EC to DPM?
Sure.
What are you relying upon for the demonstration that that is reliable?
And specifically, related to that, what do you say about counsel's argument that the conversion rates are not consistent enough?
Okay, so a couple of things there. Let's start with let's start with your question, Judge Soud, about what he based this on. So first, and I think one of your honors asked me this on my opening, where do you get these elemental carbon things to begin with from? It's an EPA study from 2003, Integrated Risk Information System Diesel Engine Exhaust Chemical Assessment Summary. This is cited in his report, Dr. Rosenfeld's report on page 14. He also used a 2002 published EPA study called Health Assessment Document for Diesel Engine Exhaust. It is cited with a link to it on page 58 of our brief. Dr. Rosenfeld then testified that the way he applied this is a way that has been done and can be done. The paper he published was actually in May of 22. It was him and several other liability experts It was published in something called Water, Air, and Soil Pollution. We do have a link to it in our brief as well, as I mentioned before. It has been peer-reviewed. I'll note that May 2022 was before not only the trial court's decision in this case, but in fact the hearing below. Now, it may have been in between his deposition and the hearing, but it's certainly something that he could testify to at trial, and this is a peer-reviewed paper. So those are indicia of reliability. One of your honors asked my opponent, is there a body of case law about this diesel exhaust exposure around the country? And the answer is yes, there's quite a few of it. The Gonzalez case is certainly one of them. We cite others in our brief. I don't know that I knew about Gonzalez at the
Is
time.
that the same Rosenfeld? Oh, you don't know. Okay.
I actually just looked it up in Westlaw, and it appears to be the same Rosenfeld, yes, Your Honor. But we cite, the two main cases I rely on aren't actually federal cases, though we do have a lot of federal cases in there, including one from the District of Nebraska, which was about a very similar kind of liability expert. But the Payne case from the Tennessee Supreme Court in 2015 and the Hess case from the Ohio Court of Appeals in 2018 are also both about liability experts. But I think the neat thing, or not neat, but the comparative thing in those two cases is that there wasn't a conversion done. There was no conversion done in those cases. Instead looking at the lay testimony and the person's employee records, et cetera, the liability expert was able to testify there had been a substantial exposure. And
Which two cases were that?
Payne and Hess. Payne from the Tennessee Supreme Court, Hess from the Ohio Court of Appeals, both within the last decade. Judge Makar, you asked about any knowledge of my decedent's work during the railroad. It was 39 years. He started there in 1975, and he died in 2014, shortly after he retired. It actually is in the record what he did, and it's in Dr. Rosenfeld's report, too. His wife testified, or stated, I think it was actually a deposition, and I think he interviewed her as well, that he worked in the same job for the entire time. He was an engineer operating trains and communicating with conductors, operating out of Jacksonville and conducting runs to Macon, Georgia. And he did this for 39 years.
Counsel, I really need you to address the inconsistent conversion rates for me.
Sorry. So to the extent that they're arguing that, first of all, they didn't show that. They have no expert. They have no one else who is testifying to that. And in the Payne case, the Tennessee Supreme Court said that's actually always pretty telling. So they don't really have any evidence that that's not the case. We aren't scientists. Dr. Rosenfeld is. If that's true, however, that only goes to weight, because that would be about the application of his methodology.
What did Rosenfeld say? I just don't remember.
Did he say about
What did he say about the conversion rates? Were they consistent or not in his view?
He said that they were. So this is, I apologize, pages 54 to 56 and 60 to 61 of the record, where he gets the conversion rate and results in this table and graph. He said that they were. And as far as
With Judge Eisenhower's permission, may I ask one question before
Yes.
we conclude?
Of course.
If this is an exposure case, why do the conversion rates matter?
I agree, Your Honor. That's what I'm saying. That even if he had never done any of that, just like in Payne and Hess, his testimony would still be admissible. There is no prerequisite under FELA or under Daubert that someone has to have translated, prospective values into an exact cancer rate or exact cancer risk in order to have liability.
Thank you, counsel. Well argued on both sides. And with that, we are adjourned.
Thank you.